Well, welcome everybody. My name is Lauren Misek-Vargas with Education Rights Counsel, and
I'm Elizabeth Einen-Kokerda with Education Rights Counsel.
And we were not here this morning, so just to kind of get an idea of who is in the room and who our audience is, how many individuals are attorneys? Okay. How many individuals are probation? All right. DHHS? Okay. CASA? Yay. All right. Any judges? Any school personnel? Any law enforcement? Okay. All right. I think I got everybody. Did anybody not raise their hand? Am I missing someone?
The Senate.
Oh, okay. Oh, perfect. All right. Great. Yes.
I'm with the local health department, the prevention for the health department.
Okay, perfect. All right. Thank you very much. I just wanted to get a concept of who was who, what everything was. So how many people have heard, I know some people here in the audience, but how many people have heard of Education Rights Counsel before? Wow, that's better than I would have. Well, we know you, Tracy. Okay. Well, that's better than I would have expected. So we'll kind of get into what our organization does and so forth, but let's kind of talk about our who we are. So ERC is a nonprofit that is based in Nebraska. Myself and Elizabeth started it in 2017. Our mission is to create systemic change by removing legal barriers to education to ensure that all children can stay in school and thrive. And so what does that look like? What does that mean? We work with children who have disabilities, who are maybe perceived to have disabilities, children who have been sexually assaulted through Title IX, who are being disciplined. So that's kind of that whole realm. Anything I'm missing?
Just anything, student discipline.
Anything education
So if
related.
you're being suspended, if you're being expelled, if, anything that is keeping you out of school, we want to look to make sure that there's not a legal barrier. And if there is a legal barrier, for example, you have a disability and you're not getting that addressed, which we're going to be talking about a lot today, or if you have discipline but it hasn't been appropriately followed, or, sometimes I'll speak to law enforcement. I don't know if you're an SRO, but sometimes we'll have an SRO in a building and that they may not be familiar with the child, and so there can be behaviors that are a part of a disability that get the child into the system. And we're going to be talking a lot about how, unfortunately, our system gets, the schools get our kids into the system. Mm-hmm. And so how to address that.
And one quick thing that we should mention. So I'm a former school teacher. I taught special education taught teachers and so forth for about 7 years. And Elizabeth, and now I'm an attorney. I was a public defender and then obviously started Education Rights Counsel. And Elizabeth, do you want to kind of explain?
Yeah, sure. I've been practicing education law for over 20 years. And I've practiced it on pretty much across the board. So I've represented school districts. I've represented teachers. I've represented families. I've represented kids. I've helped out an expert from, school funding issues. I've helped. So it's kind of run the gamut. But when Lauren and I first met, one of the things that I was doing is I was helping families. But the problem was I was realizing that I'm only dealing with maybe 10 to 15% of the families that have need in the state of Nebraska because attorneys cost money, right? And I'm making a living. And so what we were having is we were seeing many of the people that had the most need to navigate what's a fairly complex system had no assistant whatsoever. Mm-hmm. And so the way Education Rights Counsel came into being is us looking to just sitting around and chatting and saying, this is a problem. Lauren was saying, do you see this? I'm a public defender, blah, blah, blah. And I'm like, yeah, I see this. And she's basically said, well, what are we going to do about it? And I'm thinking, yeah.
She's like, we? I'm like, yeah, we're doing something.
I'm eating pizza.
Right. So when we looked at kind of what was happening across the state and if anybody was doing this work, we found out that there wasn't. And so ERC is uniquely designed to work with individuals and families of children who are 250% of poverty or below. So we're really looking at children, oftentimes with disabilities, who are currently living in poverty, which we found out is about 26,000 kids here in Nebraska. And so what does that look like? What does that mean? What kind of law do we practice? And why do you need to hear about it? We're going to chat with you about that. If it works. Okay, so let's everybody here is somewhat part of juvenile court. So how does a kid get to juvenile court, and why would education law intersect with that? In terms of a status offense, a child can come in for a truancy. As you know, if they miss more than 20 days, a school can refer for truancies. I've seen a huge uptick in this in greater Nebraska. Is that true here in Holt County, that there's been either educational neglects or truancies? I've been chatting with a lot of people about that recently. So that's one aspect. Another aspect, obviously, is neglect. That educational neglect impacts schools and access to school. It can also be, let's say that you have an abuse or a sexual assault. We'll talk about how those things can also impact school as well. And then delinquency. If a child is having behaviors, and especially if they result, they can be referred by the school, but it also can impact what happens in their education.
And then, of course, there's the overlap where you have a child of neglect who is also in front of a delinquency and also has been truant for however long.
Yes, both and. Okay, so what we found, and many of you may have heard of this term, this kind of school to prison pipeline, but sometimes what can happen is that children start in school and it can be an entry point for the juvenile justice system. And so what does that look like? Kids are being suspended, they're being expelled, maybe they are not being evaluated, and then they assault somebody at school. There's obviously an arrest, there's a referral, and then now they're placed onto probation. Okay, so now we're here in the juvenile justice system, and we're looking at all these kids who are being suspended and expelled, and as you know, the court orders, and we're going to chat about this in a moment, the court orders every kid to go to school. But do we have, as probation or DHHS, the unique qualifiers to understand how to get them back into school and make it successful without relying on those professionals? And so we're going to talk a little bit about what are those laws and so forth. Because education law is extraordinarily nuanced. In fact, in the rest of the United States, this is one of the most litigated areas in all of the law. But in Nebraska, it is not, as you can guess. And so not a lot of people understand how education law, it doesn't matter where you are in the socioeconomic spectrum, like the most wealthy families contact us and some of the poorest families contact us because it is so difficult to understand, especially without having either an advocate or an attorney. And so that is part of the problem, is that access to help.
Yeah, and I think the one thing that is up here that I want to reference is the disparity. So what we're seeing is that if you're expecting that your population is 10% X, 10% disabled, 10% minority, 10% whatever, you would expect that the discipline would be proportionate. But what we see with children with disabilities specifically is that it's very, very disproportionate. And so what we're realizing and what we see is that many kids that are in the system and many kids who got there because they were disciplined or something else that came through the school process got there because they didn't necessarily get the services that they needed. And so we're seeing this disparate discipline and disparate impact showing up in our world in terms of DHHS neglect, juvenile delinquency.
Mm-hmm. And so we have kind of a graph that kind of demonstrates this. So children with disabilities are overrepresented in every category of discipline, in most cases nearly 2 times or more. And so this just demonstrates the red is expulsion, the green is out of school suspension, and blue is in school suspension. And we'll talk about some protections that should be in place from a school that we should just keep top of mind when we are representing kids. But we'll talk about that in a moment. Many disabilities are invisible. So when this law was created, which is called IDEA, which is really what we're going to be talking a lot about today, but oftentimes what we think of is children with maybe visible disabilities, either a child in a wheelchair, a child with Down syndrome. But when we're talking about disability, here's the definition above here. We can also be thinking about anxiety, depression, PTSD, autism, ADHD. These are things that are invisible, but can really affect a child's ability to access their education. And so what does that look like, and how are we building in those supports? Not only in the juvenile court system, you might say, well, why does it matter here? But like also in the school, to make sure that they're completing their probationary term and that they're not falling into recidivism.
Yeah. One of the overall arching things you'll hear us talk a lot about is just making sure that everybody's doing their job. In other words, if we have a child that has depression, anxiety, one of these invisible disabilities, we're going to be discussing today the rights of those children and the obligations of the schools, because what we want to make sure, and we're not saying that schools are doing a bad job per se, but what we're saying is kids keep falling through the cracks. 90%, we haven't talked about what we do, but we will at the end. We're trying to get to our meat first and then talk about us later. But 90% of the kids that we accept appointments to from the juvenile court have a disability, and I would say half of them have never been evaluated for it. So one of the stats, and I don't know if we have it in here or not, is that in detention, about 87%. Oh, is it?
Click it. Yeah, it's the next slide.
Oh, okay. Yeah. Click it. Go.
Well, as Elizabeth was going to say, about 85% of youth who are detained have disabilities. And so why does that matter? All these laws that we're going to talk about actually still apply even when a youth is detained and in a detention facility, whether that it looks like a group home like YRTC or Boys Town or something like that, or in your actual detention facility. For Douglas County, that's DCYC, maybe Madison County, right, in Hall, all these things. That's what that looks like. And yet, only 37% of those facilities are actually offering that education. So we kind of chatted about this, but behavior challenges often lead to discipline instead of support. So as Elizabeth mentioned, the majority of kids that we end up representing, especially those ones that we get through the court system, are children who have not been evaluated or verified. And so I'll give you a really quick example of a case. I received a case out of, I think it was Lancaster, and the child had been beaten over the head by a bat, okay? And obviously there was a neglect, and therefore, he was removed from his parents, all right? So he was sitting in a neglect, but he continued to get suspended and expelled, ultimately from school. This is when they kind of called us in. Do you think this child had ever been evaluated for a disability? No. What are some guesses of maybe some things he might have had? Some problems. PTSD. And who else? TBI. He had a traumatic brain injury we ultimately got him diagnosed with that is a neurological change in the brain because of the abuse he had suffered. And the school continued to suspend and ultimately expel him for something that he literally could not control. And it was a direct result of that abuse. And so this is why this intersection is so important. And when we start to see kids who are being disciplined all the time, sometimes we think, it's your choice. You really need to shape up. But what we're not looking at is what happened that led to this. What is that trigger that potentially got this child here that we may need to be looking at what the responsibility is on all parts?
And I want to look a little bit more on this specific example here with ASD, because we're seeing this more and more, where what happens is on the surface, TBI, PTSD, ASD, and ODD can look similar, right? We're getting behaviors. We're getting behaviors where kids can get out of control. They can, take apart a room. They can slug somebody. But I saw somebody going, yes. Going to what's the underlying issue behind it, what the remedy you'll be doing in terms of an instructional approach in schools, and what you'll be expecting that child to do and the accommodations you would be giving them because of their disability will be wildly different. So I start freaking out in class and I get up and I throw something and I walk out. All right. If I have ASD, I could be so neurologically, I'm overwhelmed. This is in a gym. There's lots of noise. I got to get out of here, right? And so I storm out and then I get disciplined for disrupting the school, etc. So because nobody can see it. And especially what we find is, so a child the spectrum is a spectrum and they're all different, right? Some children on the spectrum have multiple comorbidities. Some are over here where, you have to be with this child for a period of time to realize that they are not catching on to the social clues. They're hanging in there and they can be very bright children, but at the same time, not be able to understand the communication that's in front of them. And so then they communicate very poorly on the way out. And these are the types of examples that we're seeing across the state and especially in the juvenile system.
Mm-hmm. Does anybody have anybody that's coming to mind? Keep that person in your brain as you're thinking about them.
Yeah.
So the next thing is something I had referenced to previously, which is the court orders. Is this a court order that is typical here in county court when you have a juvenile that comes through that they attend through probation? They attend all regular classes, school without unexcused, absences and tardies. Okay, that sounds really great. Like, we're going to get them to change their ways. Probation, how easy is it to get them back into school?
Not so much.
Yeah, not so easy. And do you have those tools to get them there sometimes? Sometimes, right? Exactly. So here is something that it's actually court ordered. And sometimes it's what's standing in between a child from terminating successfully from probation or from a neglect case, potentially reunifying with their family or being placed in an adoptive home. So we're going to talk about this, but this is why this matters. This is why education, when we're thinking about it from a holistic perspective of juvenile court, we can talk about mental health. We can talk about recidivism. We can talk about, many things, right? How they're interacting with law enforcement, how things should be addressed. But education oftentimes has been neglected. And so what does that look like? And how can we empower you to start asking the right questions? And that was kind of but what happens if the juvenile cannot successfully attain school due to a disability? So today we're going to be talking about specifically those children potentially with either disabilities, maybe that you know of right now, or you might not know of, because they have an extra level of protection, which Elizabeth's going to talk about.
Okay, great. So we're going to talk about what a school's obligation is, and then we're going to ask some questions about what you might have experienced yourselves in many of these environments. So first of all, the main, non-discrimination. We do not discriminate against kids on the basis of anything, including disability. And there are two laws that go to that. There's something called Section 504 of the Rehabilitation Act. Has anybody heard of 504? 504 plan. Okay. There's 504 plans. Does anybody tell me what a 504 plan is supposed to do? Anyone?
Accommodations.
Okay, like?
Maybe a standing desk or breaks or a water bottle with them.
Yep. Or headphones or fidgets or right.
Schedules.
Yeah. What does it not include?
Measurables like their progress notes.
It doesn't include instruction. Right? It gives you accommodations. So accommodations, which come under Section 504, which is alive and well, and we'll be talking about it. Accommodations are, we've changed historically in the United States, way back and not too long ago when I was still around. We basically said, oh, you have a disability, so sad, too bad. You don't fit in with society. And then we've changed our approach as a nation. And we've said, no, we're going to do accommodate. We're going to make ramps. We're not going to say you don't get to go to court because it's on the 6th floor and you can't get up there, so sad, too bad. We have said we are going to accommodate to integrate all people that have disabilities to the best of our ability. So that 504 is one of those. Then there is ADA, Americans with Disabilities Act.
This is easier.
It's easier to fact?
Yeah.
Okay, all right. Let's do it that way. So here's the slide that goes along with what I'm talking about.
That's easier.
We have a lot of fun together. Sorry about that. And she calls me out on stuff all the time. So the Section 504 is the first law that was related directly to education. All right. And it arose out of an historical context of a variety of actions by the disability community. So everybody in the room's heard of Brown v. Board, right? Brown v. Board. And Brown v. Board was what? Separate isn't equal. I mean, these are the basics. All right. So, but the disability community took a hard look at this as well and gained lessons from this. And we talk a lot about this when we teach ethics, which is that in Brown v. Board, what people don't necessarily know is that the individuals that were arguing against integration made a very specific argument. And that argument was, Your Honors, you can't possibly mean that we're going to integrate on the basis of race and say that separate isn't equal. Because if you say that, you know what you're saying. You're saying all those children that we have in mental institutions that have disabilities, you want them. You're saying Native Americans. You can't possibly mean that you want to integrate Native Americans. You can't possibly, and the court said, yeah, we actually meant that. But it took a little while, and all of us that went to law school, the lawyers in the room, we all studied Brown v. Board, but we didn't study the Parks case or the Mills case, which is essentially the disability case of Brown v. Board, where people, they had sit-ins, they lay down in front of buses saying, I can't get on. These types of activities went, and out of that came, from an education perspective, 504. ADA, and I'm going to go to the third column because we're going to be talking about the first column the most. ADA didn't come in until 1990. Now, I know, I can tell by some of you, okay, some of you in the room, you were alive a long time before the ADA. All right, so in a sense, people feel that this is, it's been around forever, but it hasn't. And so it's been difficult for communities and for school districts, especially school districts in greater Nebraska, where we built these schools in 1919, and we don't have the resources to put in an elevator or make the playground safe or access a wheelchair or whatever it is. So these are laws that are now in place that protect ADA and 504 still apply now. But what we're going to talk about most today is the IDEA. Note that it is an education law. It's not civil rights. It's not based out of the whole Brown v. Board thing. It's based out of this idea that we're going to give you federal dollars, and if you accept those federal dollars, you will follow certain rules. Why? Because there is no federal constitutional right to education. It doesn't exist. The only way we have a right to education is through our state constitutions. Our state constitutions were enacted with education because if you didn't put that in there, you didn't get to be a state. Okay? So you had to prove that you're going to do something to raise responsible citizens, because we're not going to have a state that does not have responsible citizens that can actually participate actively in a democracy. Okay. So we all have this, but it arises out of states. So states have to make a choice as to play or not. Every state has made the choice to play since this was enacted in 1973. Five. Thank you.
It's up there.
Okay, good.
I'm sorry.
But what I want to compare that third column over there about what's the purpose. So the purpose of IDEA is to address specifically educational supports from birth to 21. All right. So every person with a disability in Nebraska has the right to educational services and support from the day they're born till the day they turn 21.
So one thing I just
the year they turn 21.
One thing I just want to say about this then, and we're going to be talking about a law called Child Find, is, so normally, right, in 1975, probably what they thought is, I'm a woman, I'm going to have a child, the child has Down syndrome, I birthed that child, I know that likely they're going to need speech or some other supports. I go to the school district, they say, hey, can you please help me provide these supports through this law? And they'd say yes. But what happens, and I just want to start contemplating this question as we go through this, what happens if a child is sexually assaulted by their parent and then gets PTSD? Okay, but now they're 15. What happens then? So be thinking about that as Elizabeth keeps talking.
So we're going to talk about these different rights, but I want to start focusing on IDEA, because what IDEA, you'll see the line that says disabilities, but what IDEA is it's not a diagnosis, all right? Under 504, if you have a medical diagnosis or you are regarded as having a disability or treated as having a disability, you get these rights. Under IDEA, no diagnosis is required. If you're really you just love to read at night, then there are guidelines, and every state has guidelines except Iowa, which doesn't require a specific label on a child's head. Every other state requires a label, and that label has to fall into one of 13 categories, and we'll talk about what those categories are. But we label, and then we provide services for everything, whether it fits under that label or not. So that's IDEA. Okay. All right, here's another heavy lifter. Here's what we're going to do. We're going to heavy lift through this slide for 7 minutes. You get to listen to me. Then we're going to stand up and take another break. And then we'll come back and learn some intricacies, okay? So IDEA has all of these parts. It has Child Find. I'm going to tell you what that is in one sentence, and then we'll do more about it. Basically, Child Find is the financial duty of every school district to locate every individual 0 to 21. And if there is a suspected need for services, if the child may, I put that out, lawyers may is different than shall. If they may need disability, they shall be evaluated provided the parent consents. Okay, so that is a duty upon, and it's a geographic duty. It does not mean, oh, you don't go to my school. It's you live in my area. You may go to St. Paul's. You may be homeschooled. If you are in my geographic area, I, as a school district, have the duty to locate you. Well, how do we do that? Well, we'll talk about that later because I'll get into it too much. Okay. What I do is I ask, may I please evaluate you? That's called the MDT. It stands for multidisciplinary team, and it's really a multidisciplinary team eval, but we drop the eval and they call it an MDT. There's lots of acronyms in here. Once we do the MDT, one of two things happens. Either we verify, we stick that label on your head, or we don't. If we verify, what we do is we create an IEP, an individual education program. Okay? If we don't verify, and families or whomever appropriate assessment. In other words, you don't think that the school did a complete evaluation. They only did, maybe they only looked at behaviors and speech. They didn't look at academics. They didn't look at social emotional. They didn't look at fine motor skills, gross motor skills, whatever they missed. You can ask for an IEE, an independent education evaluation at the expense of the school district. One way or the other, let's say you go through this and you get this IEP. It has various parts. It has goals, it has objectives, it has parental concerns, it has these parts. It also has FBAs and BIPs. FBA stands for Functional Behavior Analysis. That is where we were talking about. Why is the kid taking off stuff and storming out of the room? Is it because they're overwhelmed? Is it because they're really angry? Is it because they have PTSD and they're, or the anxiety probably wouldn't overly, What is causing the behavior that we want to address? And then we create a BIP. So it's like the PIPs that somebody else was talking, a BIP, okay, a behavior intervention plan. A lot of schools call them PBIPs, positive behavior intervention plan. And we're going to talk about what is that, because what it is not is, Lauren, stop acting like you have a disability even though you do. Sit down, shut up, and do what everybody else does. That is not a behavior intervention plan. But we often see that set out as such, okay? Then we also have, manifestation review hearings. So how many of you guys have a kid or can think of a kid with a disability that's getting expelled because they're basically evidencing their disability? Okay. How many of you attended a manifestation review hearing for the kid?
Ooh, some.
A couple. Okay. So
it's better than.
Here's the deal. If I have a disability and you're going to change my program for 10 days or more, and that's not all at once. So in other words, you sent me out for in-school suspension for 2 days, then I got an out-of-school suspension for 3 days, now you want to expel me, whatever it is. When we add up to 10 days, and it can even be partial days, and it can be since the beginning of the school year, it recycles every year, all right? You have to have a manifestation review to determine what? If the kid is manifesting a disability. Because if they are, we go back to square one. We do not pass go and collect 200. We go back and we say, we need to do this FBA and BIP. We're going to talk more about it. Okay, transportation is available. Transportation is available if you cannot access your education without transportation. But that doesn't necessarily, okay, let me give you some examples. If I have autism and you want me to walk 4 blocks away and catch a bus to get to school, but I don't speak to anybody and I also have direction issues, that could be scary. It could be dangerous. You may need to give me a ride to school. Okay, that's one. Lauren, I'm so proud of the other day, because this was my case and she was covering for me. We had a girl who had been sexually assaulted. And she was being triggered by smells because her sexual assaulter used a particular kind of laundry detergent, and it was a common laundry detergent. So she smelled it a lot, right? Think about, I don't know, one of those dryer sheets, whatever. So we couldn't get her on the regular city bus, this was an Omaha kid, and she didn't live far enough away to get transportation, we couldn't get her on the city bus because she was freaking out. So in order to access her education, based on her trauma, she needed transportation. So transportation is a bit bigger than you might think, okay? I'm going to rant for 1 minute about shortened school days. How many people in here have had a kid that the way we're going to solve the problem is we're going to shorten their school day? Okay, every school district that did that, I want to come and yell at them. Okay, because the only time we should have a shortened school day is when it's the benefit of the child because they physically can't take it. They're on chemo, okay? Or maybe they're so anxious we're trying to edge them back into school a little by little. But saying your behaviors, Lauren, here's what we're doing. You can't behave for the whole day. So we're going to send you home, and you can come for part of the day, and you can earn your way back, honey. All right? That's not a thing. It might be happening, but it's not a thing under the law.
And we're going to talk a little bit more about this under least restrictive environment and talk about kind of this continuum of care. But one thing that you should know is that school districts are obligated to provide 8 hours of instruction. And so if they're cutting a child's day in half and saying, hey, foster parent, go, especially DHHS, go pick up the kid in the middle, and the foster parent's like, hey, I'm going to, get rid of this because I can't I'm going to lose my job. Like all this stuff is happening. I've had a district pay the foster parent then. So just thinking about what other alternatives are, there's always options. Even in greater Nebraska, we can always think creatively. Okay.
5 more topics, then you get a break. All right, next topic on that same square is ESY, Extended School Year. ESY is part of the law. It says you need to offer ESY. ESY is not, I repeat, not summer school. If summer school is available for everybody, you don't say, and you need ESY, but all you get is summer school, because you just robbed me of my ESY. What is the purpose of ESY? Extended school year is for a kid that's either at a cusp of learning or that takes a lot longer to get back in the swing of things. We know that they lose more, the summer slump in terms of reading or whatever it is. Everybody comes back. They take 2 to 3 weeks. They're back up to speed. My kid takes 6 or 7 weeks. Not good. Or my kid really has anxiety or has ASD, needs to already know what the school looks like, needs to get those patterns back under their belt. Maybe they need to stay in school for a period of time. Maybe all summer they need somebody touching base with them. All right, touching base 3 times a week just for a half an hour, just to keep them in the swing of things. ESY can look any way you want it to, but if you have a child that has one of these things, ESY is something that should be considered. What we often see in IEPs is the ESY box is already checked. Nope, doesn't need it. Don't even talk about it. Let's move on. And you have to stop and say, what data do you have that says they do or do not need it? Right? Because everything should be data driven. If you can't say because I thought so, right? You have to be able to say, I don't need to provide this. That's ESY. Transition, this is really important for people where we have kids at 18, 19, 20, and 21. Remember, it's FAPE, birth to 21. So you might have a kid that's going to age out of the system. But if they still can't balance a checkbook, they still need very specific skill sets. They don't know how to get themselves on the bus. They don't have living functional math. They can't, all that kind of stuff. That type of education continues to be available and is required to be provided until the child ages out at 21 or meets the goals. We're going to talk about setting goals because goals are really important, because if you set crappy goals, well, then you're going to achieve them and you're not actually going to get the benefits. So transition is important. We'll talk more about it.
One quick thing I just want to say about that. It starts at 14. So those plans that are being developed start at 14 years of age and thinking through that continuum. So whether or not they're going to graduate, maybe they're going to graduate, but they don't have those functional skills, as Elizabeth said, they can complete their academic work and still get functional skills. And they still owe them that until they're 21. Yeah. So you start creating that plan at 14 years old.
So some kids maybe are functioning at a 5-year-old level and they're 18. Other kids are functioning maybe at, they can read, they can write, they can do basic math, but they still have so many skill sets they're missing. So it's a really wide continuum of what's available for your child. And we're ranting about all of this because what we want to do, obviously, is always get children in school, stay in school, make them thrive, get them the opportunity to succeed. And so whether it's rehabilitative or whether it's just getting them out in the world, getting them out of the nest appropriately, this is an important tool. 3 more topics. If you have an IEP, And nobody provided you the service. I'm supposed to have speech therapy, but my speech therapist got pregnant. She's out for 3 months. Nobody hired a replacement. I didn't get speech therapy. You owe me. That's available under the law. Make sure you get it if you lost it. Prior written notice, that's basically you say, I want, or school says we want, or everybody says we agree upon. We give you what's called prior written notice. It says, here's what we talked about. Here's what we're going to do. Here's why. Here's what we're not going to do. Here's why. That's really, really, really important because when you get to the final step, which is what are your overall remedies? So lawyers want to talk about remedies. We're not really going to get into that at all in this presentation because that could be another 8 hours. But essentially, there are very specific remedies that are available if IDEA is violated. And what you do is you use your prior written notice plus your IEP to bring what's called an administrative due process action or a state complaint. We're not going to talk, but basically it starts going to an administrative level. And then after that, it gets up to real court level. But there's this whole due process structure within IDEA.
And one quick thing that it's right at the bottom, this IFSP, especially for those in DHHS, if you have a child who's under 3 years of age and has either a known disability or maybe isn't meeting developmental milestones, this is the plan that would be created by either the local school district or the educational service unit. Many kids get referred for EDN network, right? This is kind of what they help develop and create. So it's something that can then transition after 3 years old. It transitions into an IEP.
You're going to get a break in 1 minute. The reason we're getting all this up is we're going to lead into making sure you're identifying these things. Because how many people have gone through an IEP and you sit down and they say, let's introduce ourselves. There's 10 people, right? There's you, your kid, maybe a parent, and then 8 teachers, right? And you don't know what's going on. Our goal here today is to help you know what's going on so you can actually advocate for the child so that your child, whether you're probation or you're a cop or whether you're DHHS, so your child gets what they need. Now, sometimes they're getting it and they're not availing themselves of it. That's a different story, but we want to make sure they're getting it. Okay, 5 minutes. All right, guys, let's pull it all back together. I want to share some questions that we had over the break because I think it will help some of you. I had an individual ask me, okay, if we got this IEP that we're going to be talking about, does it last? What happens? What happens if I get like the eval and then my family moves? And the answer is these things stick and they're portable. So once you have a child that has an evaluation, even if you haven't finished the IEP, let's say I get the eval and we verify and I verified as ASD or I verified as OHI, I have ADHD. Then I move. That all the family has to do is take the verification to the new school district. The new school district will be now on notice that the child may, and in fact does, may need special programming, and they'll put the IEP in place. If we get the MDT and the IEP together and then I move, we take it to the next district. The next district may say, well, we'd like to re-eval. Okay. They have a right to reevaluate. We'd like to have a new IEP meeting to talk about services. Okay, but the IEP doesn't go away and it doesn't expire. IEPs have to be done every year. So an MDT has to be done every 3 years. An IEP has to be done every year. But if the school district misses the IEP, it's not like they stop providing services. They're now providing services under an IEP that may or may not be meeting the child's needs. And you probably, from a legal perspective, have a violation of free appropriate public education, FAPE, which is what is required under IDEA. Ma'am.
Question. You said the parents should take that to the new school?
Yeah.
Are the old school obligated to send it?
So the old school, if the new school asks for it, the old school has to send it. But if the old school doesn't know where the family went and the new school hasn't asked, they don't know where to send. So, but the parent can always bring it with and or say, hey, my kid had an IEP at old school district, and then the new school district is on notice that they need to go and get that.
That's something I don't think a lot of us knew, because I always thought the old school, if they knew where they were going, was obligated to send it to.
They're obligated to send if they're asked to send, but the asks it comes from the new school, right? If the ask doesn't come, it's a problem. But you can see why. All right, I have no idea where you went. Right? You up and moved. You didn't tell me you were going to a new school district. You moved. So what am I supposed to do?
Does that go with school records when they request school records?
Yes.
Or it should. One quick thing I also want to bring up that we didn't discuss but came up in a conversation is a terminology called predetermination. Let's say that you want to get a child an evaluation, or you think that your kid deserves X, Y, and Z, and you come into the meeting and the school says, we're not doing that. Has that ever happened to you before? Okay. That is called predetermination, and it is against the law. So
it is a direct violation of provision of, against the law is the non-legal term. The legal term is it's a violation of meaningful participation in the parental process, which is by law, by a series of case law, a violation, a deprivation of a free, appropriate public education. A free, appropriate public education, FAPE, is exactly what everybody is required to provide under IDEA. So free, good, right? Public, good. Education, fine. Keyword, appropriate. Free, appropriate public education, including, think about this, guys. If you don't have a disability, all you get is a free public education. If you have a disability, it has to be an appropriate one. So you have this whole body of what is appropriate, what should be being provided, what goals and objectives should be there, what services does my child need. And all of that falls within this conversation that you have to have that should not be predetermined.
And this quote that was up here previously kind of speaks to that. It needs to be reasonably calculated to enable a child to make progress appropriate in light of a child's circumstances. So we meet the child where they are. We don't, as an institution or a district or whomever, get to decide what's happening. If we have evidence that a child needs extended school year, then we should be doing that. It can't be predetermined.
Right. And we also can't say, this is also a method of predetermination, I'd love to do that, but I just don't have the staff. Okay, that you can't do, and the reason you can't do it is because you've accepted the money to do the job. So therefore, that's a you problem, not a me problem. My kid still needs it and gets it. And one of the things we talk about with teachers, because we understand teachers are overwhelmed and underpaid, and there's not enough of them. And special education is a big shortage, especially in Nebraska right now. But if you are a teacher and you are thinking, oh my God, I've already got 10 people on my caseload. If I add this 11th, I'll be here all day, every day. I can't do it. So I'm going to say he only needs 15 minutes instead of an hour and 15 minutes. What that teacher has just done is cut off their nose to spite their face. Why? Because now this kid is still going to be disruptive. This kid is still not going to get the instruction they need. This kid is not going to have the supports appropriate, and it's going to ruin their day. So speaking up and saying, yep, I really need, Billy is at grade 0 on reading, and he's in 5th grade. We need to move him more than one grade level to get him caught up, because we're always trying to close that gap. Okay, what are we going to do to close that gap? Well, we need to give him reading instruction. If what we're giving is reading instruction 15 minutes twice a week, are we going to get there? No. So, yeah, part of the IDEA, part of this, whoops, where did it go?
That quote.
Part of this quote, whoops, I don't know. Well, anyway, there's a case called Andrew F. There we go. Another part, a fundamental part of the Andrew F. decision, it's Andrew F. Douglas County, but it's not our Douglas County, it's Colorado, is that it has to be, the child has a right to meet challenging objectives. That doesn't mean you're going to ask them to speak French in a year, but it does mean that they have, you can't say, okay, honey, one letter of the alphabet, and our goal for you next year is 2. All right, that's not a challenging objective.
Okay, so real quick, we are going to kind of, I don't want to say zoom through this, but as you can see, we can chat a lot. And if you want more information about this, we do other trainings, and we'll chat about that soon. But we want to kind of go through these things that we just touched on briefly in more depth. So the first is child find. As Elizabeth mentioned, this is a school district's responsibility to find a child, or an ongoing obligation to identify and locate and evaluate all children. If the child is
children suspected
of a disability.
Not every
Thank you.
child.
Yes, suspected of a disability. So if a child is in a private school, does that still trigger this obligation? Yes. If a child's in a hospital, it still triggers, the obligation. The same thing if we have highly mobile children. So if we have migrant children or children who are homeless, it still triggers this obligation. So the school district cannot say, no, we're not evaluating this child if we have information that demonstrates they likely need to be evaluated.
And if it's a truant child, well, we can't evaluate them because they're never here. Well, we'll find them for you. We have probation. We'll pick them up. We'll take them down to the main office. When will your school psych be there? All right. They're in DCYC. Well, great. You know exactly where they are, right? Go get them.
Welcome to the detention facility.
You said this is for all children.
Birth through 21.
21. So how do the schools go about determining the kids that are in their area?
Yeah, some of it is through hospitals. Like I give birth to a child, the school or the hospital indicates that maybe there's some concerns. Maybe the parent comes to a parent-teacher conference and says, hey, I'm being abused, right? Or I'm a mom, I'm being abused by my husband and my kid's also being abused. One, that should trigger lots of other phone calls, right, to CPS and all that stuff. But it also should potentially trigger, if this child's been absent or is failing all their classes, it might trigger this as well.
Red flags are, behaviors. Whether big or young, right? Behaviors are a trigger. If your kid got kicked out of daycare, that's a trigger. If your kid is putting their head down and not interacting, if your kid is not coming to school, what is that? That's a behavior. What is behind that behavior? So there's a myriad of ways that they're triggered. It's triggered through observations in the classroom. It's triggered by parents, doctors, the gamut. And the schools have reporting, what's the word I'm looking for? Pipelines.
Yep.
Yeah. So where they are reaching out for that as well. There's a hotline that you can call. Doctors can call a hotline.
Yep. So what happens then if you now have been found? You are suspected to have a disability. As Elizabeth mentioned, then the school district's obligation is to evaluate. Now, you have to have parental consent to evaluate. But let's say that I'm a parent and I say, hey, after COVID, my kid will not leave his bedroom. He will not leave his bedroom. He has such bad anxiety, I can't get him out of the house. How many people have heard this, especially since COVID, right? I cannot get him out of the house. I don't know what's happening. He doesn't want to leave. He seems depressed, all these things. Now, if we do an evaluation, it needs to be comprehensive. They can't just say they're going to look at one aspect, potentially, of this evaluation unless the parent doesn't consent to a component. So I want to put into writing as a family, and the parent is the one who triggers that.
Or whoever has ed rights.
Yes.
Or
whoever
if you have a guardian ad
rights.
litem that has education, surrogates, and whoever's got the educational rights.
You want to put it into writing because then they have to do this evaluation within 45 school days or 60 calendar days. And there's a timeline. So if you ask for it in May and they say, we really can't do it this summer, I'm really, really sorry. Did they violate IDEA? Yes.
Right. Okay. In fact, we've had a really big problem with that, which is school districts are saying, well, we don't do evals after March because we can't create the IEP till the fall. The answer is, yeah, you do. Right? I'm sorry, you do. You do these evals. And if you do run into trouble where you actually are having a family or a kid or a school they're saying these kinds of things to you, one of the things you can do is pick up the telephone. Don't call us first. You can pick up the phone. You can call NDE. You can call their special ed department and say, I'm a CASA. I am a probation officer. I am whomever you are. I'm working with this particular family. We believe they have, they want to have an eval. We've asked for it, and the school has said they won't do it until fall, and it's April. And the NDE usually will pick up the phone. Amy Rohn, who's the head of special ed for the state, pick up the phone and say, hey, Geltner. Hi, it's me. I think you need to do this. And that sort of solves your problem. If that doesn't solve your problem, then call us.
Now, as Elizabeth mentioned previously, once that evaluation is done, we're looking to see if the child needs to be verified with a disability. Now, you can have a diagnosis and also be verified through the school, but it's not a requirement. So if you are a child who has a suspected disability, and let's say I'm a kid who every time it comes to writing, I start to have behaviors. I flip tables, I'm angry, they evaluate me, and maybe I do. Later on, we find out through probation or DHHS, I have ADHD and so forth. They could have verified me for that previously.
Without it, yeah. So in other words, you don't have to have a diagnosis. There are descriptions. If you go on ND's website, there are every single one of these areas has a set of guidelines, and each of the guidelines is 14 pages that says, here's what this looks like. If it walks and talks like a duck, it's a duck. Do something about it.
Now, there are specific areas that are highlighted here. Here are the 13 verifications that a child may be verified with. A couple that we want to talk about: an emotional disturbance. This is something that you may see quite a lot, especially if a child has ODD, anxiety, PTSD, bipolar disorder, so forth. What this actually looks like is a child who is anxious, depressed, and is demonstrating behaviors because of that. And a behavior can be truancy. I just want to highlight that. A behavior can be truancy. A behavior could also be saying, F off, but it can be lots of things, okay?
Yeah. It can be hitting somebody, okay? And so some of our kids, it can be inappropriate sexualized behavior, all right? And so what do we see when we have that? We have a child, when I have a little girl who is sexually inappropriate in the classroom, I have one of two options: figure out what the heck, or discipline her because she's trying to get sexually inappropriate with her peers. And this happens to little kids and it's older kids. We deal with young women and men who have been trafficked, okay? They do not necessarily behave appropriately with their peers because of the trafficking. And so you have to look back and just say, okay, this is not just an over-sexualized child that is completely inappropriate. There's something behind that we need to be addressing. And we need to be finding an appropriate educational program, which could include placement in a variety of different areas for that child.
So the other two, specific learning disability, this is really designated for a child who may be excelling in math and science, but is really struggling in reading and writing. So it shouldn't, if you have a specific learning disability in all subject areas, you might not be verified appropriately. It really is supposed to be, hey, we see a real huge slump in one particular area or some concerns in that area.
Yeah, I want to jump in on this because we are torn as human beings on this and as advocates. Sometimes what we see a school district do is they are loath to label the child with an intellectual disability. They're loath to do that. So instead they find that they have a reading, they have dyslexia, they have dysgraphia, they have calcula, they have, but the problem with that is because they haven't done the DD, or not developmental delay, I'm sorry, the intellectual disability label, then the child keeps moving up. And the child's never really learning to read because they didn't want to put the child in an alternate curriculum. We always want children in the most challenging curriculum. We always want children in the most inclusive environment, but we don't want to be asking them to do something that they cannot do if we could have been teaching them in an alternate methodology what they can do. So one of the things we run into a lot is we want to have high expectations, but we also want to have appropriate expectations. So we see people that are I think they think that they're doing the right thing, but we are concerned about it. Just throwing it out there.
We also talked about TBI with the example that I had previously. This is something that you should really look at Brain Injury Alliance if you have questions, if a child may have this. But if there has been trauma to the brain, it can create a neurological change in the brain, and thus the supports and services need to look differently. All right. What is in the IEP?
Oh, the IEP.
So you've been verified. Okay, right. Now we're going to create a plan.
All right.
All excited back there, whether sarcastically or not.
These are all important. So we sit down, we go into the IEP, we introduce each other's. Hi, I'm Ms. Smith, Ms. Jones, I'm the math teacher, I'm the science teacher, blah, blah. All right. Then the very first thing that we try to do is get present levels of academic achievement and PLAF. Yes. Anyway, PLAF. What that matters about is where am I now? What this does is it sets baselines. These baselines can be set because of academic assessments. It could be basic homework. It could be coming out of that MDT that you just finished. But somewhere, somehow, we know where you're at. If we don't know where we're at, how are we going to set a goal to get you somewhere? If you don't know where you are, you don't know where you're going. Right? Okay. So present levels are a really important part. We do like 2 hours just on the evals. We're not going to do that for you, but understand that this is an important part of what's in the IEP. The next thing is parental concerns. Parental concerns are very important from a lawyer's perspective or a family advocate's perspective because it's the one place you can put anything you want into that IEP. And when I am ticked off and I'm working with a family, I will have them write in. Parents are very concerned that the child has not been provided this, and this, and they were told that, and they believe that it's a violation of free appropriate public education. Write it down. Okay? And when they write it down, then they figure out maybe they should fix it. So it's a very powerful area, and a lot of times it gets overlooked because you're in the IEP, and it's like, what did parents like, well, I really would like Johnny to go to school. That's it. Right? You've lost a huge opportunity there to really talk about what your concerns are. Next, setting goals. Okay. They have to be SMART goals. They have to be specific. They have to be measurable. They have to be attainable. They have to be realistic, and they have to be time-bound. Mentally memorize that, because you see goals, and we show examples all the time. But let me give you a sample goal, ready off the top of my head. In the next IEP year, Lauren will improve her math skills from 80% proficient to 85% proficient. What do you guys think? Yeah. That's a sucky goal, even though it has a baseline, right? Okay. I didn't say okay. First of all, every goal has to tell me what you're going to give me. Given direct instruction, support, tutoring, whatever you're going to give me. If I give Lauren this stuff, Lauren, from a baseline of X, is going to be doing, let's take the math. If we just say improve math, well, at what level? Is she doing 3rd grade math or 8th grade math? When we're talking about math, are we talking about 2-digit addition, subtraction, multiplication, division, algebra? What are we talking about? You have to put that specifically in so that you can measure it. So then the next thing you're looking for is, okay, I'm going to do this. I'm going to give her these things. I'm going to do it over a period of time. And then I'm jumping, but at the end, we're going to say, and how much extra time, what services am I going to give her? And if I say she's going to be able to meet this very specific goal with 15 minutes and she doesn't, what does it mean? And I swear to gosh, if anybody says it means the goal is too hard, I'm going to have to hurt you. What it means is if you spent all this time writing a really good goal, you're not getting enough services to meet it. And that's really important as you go down the road. So
one quick thing I just want to say about this, you may be asking, well, how do I know where a kid is, right? Like, what grade level are they? If they're 17, and they're reading on a 1st grade reading level, how do I know? That MDT, that evaluation that was created, is your baseline. They are supposed to do it every 3 years. Oftentimes, and I will say this is a huge problem in Omaha, huge, is that they'll have parents waive them. And so we'll have a 17-year-old who has never been evaluated ever again since they were 8 years old. And we're working off of 8-year-old data, which, come on, when they were 8, maybe they didn't know, sight words or something like that, and now we're trying to have them read Beowulf. It doesn't make sense. And so this baseline is so imperative. If you see that you have an outdated evaluation for a child with an IEP, that's your first step, is to ask for a new one. Sorry.
Right. And I would say the only exception to that is if we have a child that is severely disabled. Mm-hmm. Okay, so they have multiple comorbidities. Giving them another Woodcock-Johnson or whatever the heck it is that they're going to give them, a Basco, Wisca, this or that, is not going to be as useful for you as it is to collect all of their data. Usually children with very specific multiple comorbidities are going to school. They're just struggling, as opposed to the kids that are also, yes, ma'am.
Could they be reevaluated if they have a new diagnosis?
Absolutely. Mm-hmm. Yeah. Now, I will tell you don't have to have a full re-eval if you have that diagnosis. In other words, I've already got an IEP. I get a new diagnosis of ASD on top of the ADHD. Okay. The only thing I'm watching out there for is I would demand immediately if what you find out is they've labeled the child ED, but it's been ASD all along, right? So, because that means they probably haven't provided the right services for years. But you can say to them, we need a new IEP, because we have these additional things and we have this new diagnosis. So we want to create some new goals for that and some new supports. You don't have to have a full eval in order to do that, but it's a good idea to get a new eval.
You had a question?
So with that 8-year-old to the 16-year-old, I've seen where then they say, well, they're not on their calendar year for reeval, which I know is not legal, but
so it's every 3 years, and technically what they may say is like, well, look, we've waived this, right? And the waiver then puts them on a calendar. I think that you can push back and say, well, then what is your baseline to create this IEP?
Right. Yeah, I would simply say, your duty is to provide a free, appropriate public education. How do you know it's appropriate if you haven't looked at this child for, 4 years? What are you looking at to show me that's appropriate? If they say, well, we've got all these mounds of data, all right, but if they don't, not all right.
Oftentimes they don't. I think
more often than not.
I think we've seen 1 or 2 school districts who actually brought information and was like, oh, okay,
yeah.
Then we don't need to do another evaluation. But that's very unlikely.
Right.
Yeah.
Yeah.
What else?
Placement.
Services, accommodation, support. Okay, so way back at the beginning, you said, what's a 504? You get accommodations. What do you get under an IEP? You get direct instruction. That's services. You get related instruction and services. That's OT, PT, school psych, nursing, ASD, behavioral, ABA, whatever it is. Okay, those are your related services that you can get. You get assistive technology, which is, it can be low tech or high tech. What am I missing? Services, related services, assistive tech, and accommodations. Oh, yeah. Hello. And you get all those accommodations to boot. Okay, so the difference between an IEP and an IEP has all of the abilities to hold an entity accountable. A 504 plan is wishy-washy. Now, that being said, often what I will do is if I see a kid and I have asked for the eval, the consent to eval is going in, and I know I've got this kid for another 2 months and before we're going to actually get this IEP, the eval done in 60 days and then another 30 days. So I've got basically a quarter or a semester where they're not getting any support. I then request, if I have a diagnosis, a 504 plan in the interim. So I don't just sit back and say, okay, I'll wait 90 days. I say, in the interim, I want as many accommodations as I can have, please, for this child to at least getting them something, because something's better than nothing while you take your time to evaluate. Or maybe you could hurry it up. All right. A placement. Okay. Now, placement, just a little tiny bit. Placement is not just a building, right? Placement is the entire program. So placement is what classes, where you're going to be in those classes, who's instructing those classes, how often you get that, and who's giving it to you. And if any of that changes, they can't do it unilaterally. I don't get to say, school districts all the time. The goal says that we're going to do this, but we changed that because he was doing just fine. You don't get to stop and change. If you're having people that are saying, yeah, we know what this piece of paper said, but we're doing something different because we like it better, that's a real problem because they determined that all by themselves. It's that predetermination. You have the right to be participatory in all of those decisions. Placement also, we will say, we're going to talk about least restrictive environment. Everybody heard LRE? Anybody hear that I'm not going to actually provide a child I'm not going to send a child to a level 3 provider because I have to keep them in LRE. No? Okay, that's good. Do you guys know what a level 3 provider is?
Yeah.
Okay, in case you don't. All right, so there's 3 levels. It has to do with reimbursement in Nebraska. Reimbursement level 1 means you're going to get X dollars if you have a kid, X dollars on top of your regular ed if you have a kid that needs 3 hours or less. Okay, level 2 means you're still providing, you the school district are still providing the service, but they need more than 3 hours. Okay, so now that could be any place, it could be a specialized, it's anything within the district that's being provided, you get this rate. And then finally you get a third rate if you literally cannot meet the needs to this child. This child needs to go to Behaven or Stepping Stones or ESU, whatever's behavior school, or Kearney, or not YRTC, but okay. So the other thing, wait, I want to do two things. Okay. Quarterly progress and stagnant. The other thing that's really important about an IEP, if you guys are gathering data, when you get a child and you're trying to help the child educationally, don't just ask for attendance and grades. Ask for everything. Ask for the counselor observations. Ask for the discipline record. Ask for the special education record. Ask for everything, because that's going to give you a picture of what's going on for the child. And one of the things you're going to get, if they already have an IEP, is quarterly progress notes. Those are going to say, here was our goal. Lauren was going to go from X to Y. And if they keep saying, adequate progress, but they never make it, it's not actually really adequate progress. So that's your checkpoint. Are we going to actually make our goal? And if we're not, maybe we should reconvene. Ma'am.
I maybe partially answered the question in my head, but I've had this question since I've started at the health department, trying to find local data that I am privy to. Like, if I call the school, am I able to ask for attendance and grades or truancy?
About an individual or about the whole school?
The whole school.
Oh, yeah. Okay. So as long as it's de-identified, you can ask for that, and they should be able to give it to you. It's a public records. And if they don't, the AG is supposed to enforce it on your behalf.
And they should give it to you within 4 days.
Yeah, there's a whole Public Records Act on that. Okay. They have to either give it to you in 4 days or respond to you within 4 days about when they'll give it to you, and if there's going to be a cost associated, and the cost can't include their attorney reviewing it, so it should be just the cost of pulling it together, as long as it's de-identified. If you're looking for a particular child, then you need parental consent to get that information. But often, if you're working with the parent understands you're trying to help them, they'll give you consent, and then you can get all the child's individual records.
All right, we're going to jump to what is least restrictive environment or least restrictive placement. So when we're looking at this, what Elizabeth said previously is when we go back to Brown v. Board, the entire idea behind this is that we are not segregating children with disabilities. So the concept is we as individuals with disabilities are then placed into a general education classroom. We're getting as much access and inclusion that's possible, that we're with our general education peers. So this is kind of a continuum. If you look at the top, and it's kind of hard to see, it starts out at a general education classroom. Then maybe you go to getting accommodations. You have that 504 plan. You then might be getting individualized instruction. Either you're pushing in or, you're supposed to stay inside the line.
I know I was going to point, but Tracy's going to yell at me.
Push in. You either can be pushed in, like a teacher comes into the classroom and helps assist you, or you get taken out of the classroom for a brief period of time, which might be resource. It could be called many different things. Behavioral skills class, there's a gajillion things. You might have part-time class. Part of the time, maybe you're in a general education classroom for math and science, but for reading and writing, you're in a special education classroom. A self-contained classroom is a classroom I taught. It's all children have special education needs, and they're there the entire day. You then might have kind of a special day school. This is what we were talking about in terms of that level 3. In Omaha, this might be Alpha, Heartland, Boys Town has a level 3.
Monroe Meyer.
There's different kinds of ones. And then a residential facility, this would be a PRTF, like for mental health concerns. And then home instruction. Do you see how nowhere on this continuum does it talk about shortened day until you get to home? So that's the key factor. If they haven't gone through this gamut of trying things, then sending the child home isn't really the solution.
In other words, what we often see is I have a child. He's in general ed. He's going to all general ed classes, except he's getting tutored in math. All right. He's a grumpy puppy. He's not very nice. He says mean things to the teachers. He instigates people. He's in a class and he's always rattling his water bottle. And, so we want to send him to a level 3. We went from square 1 to square 5 or whatever, 7. Square 1 to 7. That doesn't cut the mustard. We have to try these other things. We have to say, well, what if he has a one-on-one with him? all day, every day. What if, what if? We're always trying to do these things. That's not to say sometimes we're not on the opposite end saying, don't tell me you can meet this kid's needs in a general ed classroom. You clearly haven't been meeting them. They need this much more structured environment. But you need to go through this whole thing. You can't just jump from point A to point Z.
And I'll give you an example. We had a client who was assaulting a teacher, and is extraordinarily aggressive. And in that circumstance, the school district was like, well, there's nothing we can do. Okay. As a former teacher, I obviously have concerns about her safety. I have concerns about this child potentially being criminalized, right? There is absolutely no way that this district could support this child's needs. She really needed to be in kind of a mental health facility. And there was a lot of other things going on. Okay?
Yeah, I want to address that criminalization for a period, because this is why we look for additional supports. I have a child right now. He's in like 5th grade. He does act out. He's on the spectrum. They've been actually treating him as if he has an emotional disturbance, but he's on the spectrum. But they have him in a segregated class. It's down the hall. It's over here. Well, what they told him to do when he was starting to get dysregulated is to go calm down out in the hallway. Well, he goes out in the hallway, but guess what? He's not calm. So he's disturbing the peace. He literally was arrested. Okay, he was arrested for disturbing the peace in the hallway of the classroom where he left, because that was his plan, but he wasn't very calm when he was out there. Okay, so we are very, very concerned about criminalizing the manifestation of a disability. And so one of the reasons we really want to find the best placement is so that we aren't putting children at risk of being held accountable for things that they literally can't fix. This child actually was required to do community service to get off of probation with his ASD. Yeah, it was just not, it's not the right solution. Criminalizing these behaviors is not the right solution.
And one thing I just want to highlight there before we get to kind of disciplining of students, which we're going to talk about here in a moment, when a school district says part of the reason that there's motivation sometimes for not moving kids into different placements is because it costs money. They have to contract with another entity or a provider to provide this service, to provide this support. And so when they say it's not possible, the law actually does allow for it. You have a question?
Yeah, just a comment, I guess. Part of the time, it's not because they don't want to because of the money. There are no places open. There are no slots available.
Yep.
Call.
That is true. And a lot of districts have difficulty contracting with certain providers. Yep. And so something that we have worked with NDE is trying to think through that as a solution, especially for Greater Nebraska, and trying to provide different supports.
But I would also say, though, alternatively, sometimes you need to ask and re-ask and re-ask. And what happens is, okay, if the whole team has said, yep, we really need an external thing. The entire time that they're not providing that, even though they've called and been told we don't have a slot, that's still denial of that free appropriate public education. So to light a fire under people sometimes is to say, every week, did you call? Did you check? Was there a new vacancy? Did you call? Did you call? Because you're accruing this violation, even though that it's not, I'll call it intentional. This child is missing out on access to education that they need, supports, which is going to entail compensatory ed once we find a place.
Lots of questions here.
Not just a comment.
Yeah.
There's got to be exceptions to what you said about not wanting to criminalize behavior, and I appreciate that. I practiced law here in O'Neill for 47 years. I've been a guardian ad litem for most of that time. I have a man who's now, I call him a man because he's now 18 and he just graduated from high school. The case emanated from Amy's high school where he threatened to shoot up the school, and so we got him. He got this hard place, placed him out in Wyoming where he and a couple of his buddies out there conspired to throttle the night staff person and steal her car and run. They were going to hit her over the head with a fire extinguisher. Fortunately, they didn't do that, but they choked her until she passed out, and they took her car and they ran. The state of Wyoming didn't do anything to him. They put him in detention for a number of months, but when they started to look at what the bill was going to be for adjudicating him and or convicting him of what was a felony, they just passed. So we went and got him, brought him back. He was in a number of different other facilities. Lately, he's been in couple foster homes in Lincoln. He's a nice kid. He went through the Omni program with Seward and did a real good job. But then he's employed at like Walmart, so what's he doing? He's shoplifting. He gets caught. Then he gets another job at Walgreens, and now just lately he ran after he turned 18 at the end of May. And at his latest court hearing, we of course brought out that we had copies of all of his email or his electronic stuff, where he was researching what would happen if he ran after he was 18, not 19.
Yeah.
And so,
so you have a smart cookie. Yeah. So let me clarify the criminalization issue. And what I guess I'm saying is that we're not saying that.
and then you can,
Okay, go ahead.
But so my point is that there's got to be an end gate to where if you just keep turning the other cheek and letting this go, he's going to believe that criminal behavior is acceptable. And then when he gets out of the juvenile, well, now he's past 18, so now he's not protected by juvenile court. So he would be subject to felony prosecutions if that happens. And I believe that will happen. So that was my point. I agree with the general thesis about not criminalizing.
I think the thing here is that what we're trying to show you, especially as an attorney, right, is that there's other issues at play potentially that are coming to be. Do we have clients sometimes that we provide all these supports for that still are engaging in some of this behavior? Absolutely. And do you think we're sitting there saying, hey, there's more we can do? No, we've run the gamut in terms of all these things, right? So I don't think it's necessarily about necessarily turning the cheek. It's about sometimes children with disabilities can be criminalized for what is a manifestation of their disability. And what we're going to chat about next is what that discipline looks like, and then we can keep talking. Okay? Okay.
So, and I want to... All right, let's talk about this within the school context, because I agree with you. No one is disagreeing on the fact that there can be criminal behavior. What we're saying is, let's try, if we have this in the school, not to be arresting children in the school for behaviors if we have not already put in the appropriate supports and services. So what happens is, for the discipline of students, and you heard me talk about this a little bit earlier.
And one thing I should probably say, too, in terms of an exception, you mentioned guns. Yeah. So drugs, alcohol, and guns are an exception to this law under this the Student School of Conduct. Even the threat of,
So, so in other words, it's very, very, very difficult to say I brought a gun to school because of a disability. Now, we did have one kid who was picked on and picked on and picked on and picked on and picked on by the vice principal. That still doesn't make it cool to bring the gun to school to take care of the vice principal. Okay, then we're not saying that. But so that's very hard, and the law doesn't allow it. Same thing with drugs. Even if you are addicted and you have a drug addiction, that drug addiction is not excused under the law in terms of it's a manifestation of your disability, so therefore you will not be held accountable for your actions. So drugs and guns are two different things, and they're outside.
That's rain.
Oh my gosh!
It's been coming down.
I'm like, what is that noise? Okay. So setting that aside, when you are having a discipline, we talked about this, if you have been disciplined for 10 or more days that are it can be consecutive or non-consecutive, that's considered a change in your educational placement. So before you change that placement, it's like changing your IEP. You need to come together, you need to have a meeting about whether we should be changing the IEP or whether we should be disciplining the child. So, I stole a car, I drive it onto school grounds, and my disability is reading disability, probably not related to my disability, right? Maybe if it's ADHD and I got really distracted, or maybe not.
But another example of this would be, let's say I had a little girl, every time, she got really frustrated, she didn't know how to read. Every time somebody tried to redirect her, she'd say, F off, blah, blah. She had ODD, okay? She had an emotional disturbance. Maybe that they kept suspending her for basically disrespect or inappropriate language.
So in other words, when it's linked, so what you're looking for is, I don't like what you're doing. What I really want to do is have a behavior that I like. But we want to find a replacement behavior that meets your needs and the school's needs. So in other words, when I get mad, I tick this up and I hurl it. Not a good plan, right? We can't do that. So what do I need to be taught to do instead of throwing water bottles at your head? I need to be taught to, I need to be taught about emotional regulation. I need to be taught about anger management. I need direct instruction on that. I need examples. I need to be rewarded for engaging in appropriate behavior. And that's one of the things we will implement if what we see you doing is actually a manifestation of your disability. Yes, sir.
We have you for another 7 minutes.
Yes, you do.
Those of us who actually have to go do something about school districts that either aren't providing IEP, better yet, not doing anything with the IEP. Would you take 2 or 3 minutes and talk about practice tips, please?
Yeah, I mean, this is one aspect of those practice tips, and if you want to know about
actually going to court
in terms remedies, yes, yep, you're going to have to sign up for another training, my friend, because this isn't it. So let's talk about what happens in a manifestation determination, okay? In terms of the discipline, what happens when a child's been disciplined for more than 10 days? It doesn't have to be consecutive, and it doesn't have to be in a row. What happens is that the school district has to have a manifestation hearing or a review hearing. At that review hearing, they have to ask 2 questions. The first question is, was this a direct or substantially related to the child's disability or a manifestation of that disability? If the answer is yes, the child cannot be suspended or expelled, and they have to go on to the IEP team meeting. Okay? Now, let's say the answer to that question is no. What happens if the next question was a direct result of the district's failure to implement the IEP, to implement the behavior intervention plan, to implement those things? If the answer is yes, that the district failed, then the same thing happens. The child cannot be suspended, the child cannot be expelled, and now this has to go on to an IEP meeting.
But the scenario of you stealing the car, driving it onto school property because you have a reading disability,
Yeah.
it won't fly with you.
That's not going to fly.
Yeah, probably not going to fly.
Well, if you get the kid off for that, I want to talk to you.
Yeah.
No, and nor should it, right?
Yeah.
I mean, really, what we're really fundamentally talking about, and going back to the gentleman's concerns, the reason we do all this is to understand what those children's rights are. If you don't understand what the rights are and what the remedies are and the entire administrative process before you get to court, you're going to mess it up in court. So, unfortunately, there's certain levels you have to go through of understanding what's out there so you can then effectuate the children's rights. And we're trying to effectuate them before we have to get into court. What we're trying to do is remedy this at the school level by showing them you blew it, you denied them FAPE. We can either go to court and ask for remedies, or you can fix it.
And to be frank, in a juvenile court construct, the juvenile court can't order the school district to do anything. They don't have jurisdiction over it. So you can't have the juvenile court order the school to do an IEP or so forth. So you have to play in this administrative world.
All right. You know, I want to, because we only have 4 minutes, and I think there are some questions. We talked about transition services, and we talked about IEPs continuing in alternative environments, which is just because you go to DCYC or Kearney doesn't mean your rights to have instruction and the supports in your IEP stop. They go wherever you go. And we talk a little bit about what we do. One of the reasons we're here is to build an alliance of educational advocates. The reason we're talking to you is because we could make ERC as big as half the state and it's still not going to meet the needs of the kids. We don't need to have 55 employees. We need you all to be able to go out and help effectuate those rights. So that's why we're here. And we do a lot of different things. We've all been talking about the number one thing we do here, access to equity, and the programs that we have with regard to dealing with families and clients. We also do trainings like this. We also do a lot of research and data gathering. With that, what we'd like to do is say, everybody here has a role. Everybody here can be part of that solution to rehab the kid. What's our whole goal is rehabilitation, whether or reunification, both, depending on what why your child's in juvenile court. So these are the various roles that you can think about. We want you to think about these questions. If you're a county attorney, what should you be asking before you bring a matter? If you're a probation officer, what should you be asking of the family and the kid and the school to see what's happening? Because maybe you're going to want for different services. If you're an advocate, if you're a CASA, knowing how to navigate this. Everybody has a piece of this pie, and our goal is to help you have a better understanding of that pie. And finally, we have 2 seconds for questions.
And if you have further questions, on our website, we have a consult sheet. We take consultations from attorneys, from probation officers, from anybody in the community, and you will meet with one of our attorneys to chat through your specific problem. So any generalized questions? Yes?
Do you work with families at all that have involved or have a client that has a health issue with a child?
Yes.
And the school refuses to believe there's a health issue?
Yes. If they go through our kind of system, our consultation process, if they aren't in Lancaster, Sarpy, or Douglas, we will go through that consultation with them, and if they are an individual or 250% of poverty or below, then they may be taken on by one of our attorneys.
Yeah, we will provide a consult to anybody. You can be rich, poor, you can be calling as a doctor, a lawyer, CASA, you can call a family. We'll talk to anybody, but if we undertake actual representation, it's within a framework.
Okay, perfect. Mm-hmm. Tried 3 attorneys and came to the first.
Okay.
Thank you.
Yep, no problem. Any other questions? Yeah.
When you were talking about the least restrictive environments, do you have to physically go through each of those, or can you, as the group, with the parents' involvement, talk about these environments and get a consensus of, no, we really need to jump ahead a couple of steps?
Well, yes. What you would do is you would say, well, we've tried this, this, and this, or we don't think this is going to be effective because of these things. So yes, we can go to that. But you have to make that mental checklist in your head. Do we believe that we can do it in the lesser restrictive environment, or is that not going to meet the child's needs? Okay. If it's not going to meet their needs, let's get them where they need to be.
Yeah. I didn't want to help.
You don't have to go through every single step to get to that conclusion. Yeah.
If you have a child that's in a 3A case and the parents are refusing to submit to an evaluation, like on the younger kids that aren't in school, what can you do about it?
So if you have a 3A neglect case and they are refusing to consent, I had a family who believed they were sovereign citizens or something like this. They had 12 kids. They had homeschooled their children. You have somebody, I see law enforcement nodding. They'd homeschooled their children. The 15-year-old couldn't read, okay? The parent wouldn't sign a consent. Essentially, we came with the information to the court and said, look at all this body of evidence. They are refusing and continuing to participate in the neglect of these children educationally. The court then can order what's called an educational surrogate. Through that court order, it can either be an attorney. I know some counties use CASAs or foster parents and so forth. You just want to ensure that whoever that educational surrogate is understands these things so they can actively participate in that child's education. Yeah. Any other questions before we go? Okay, please write down our information. If you have any further questions or anything, please let us know, and we appreciate your time and having us here in O'Neill. Thank you so much.
And I will say that 3.5 hour video is on the CIP YouTube channel.